On February 26, 2025, the House Committee on Natural Resources held a meeting on the implementation of the Endangered Species Act and the Marine Mammal Protection Act. This video is going to cover the necessary background to understand what they're saying in that meeting. Specifically, we are going to cover how agencies enact the will of Congress, and we're going to cover two legal decisions, those being the Chevron Doctrine and the Loper decision. So I wanted this video to cover the entire meeting. However, I have far too many time constraints that makes it impossible to put that video out in time with all the editing that I wanted to include. Primarily, the time constraints being there's another meeting on Tuesday, and I am supposed to be visiting my family for a few weeks for the first time in a couple of years. So what I am going to do in this video is I'm going to keep the editing down to a minimum. We're going to use my little drawing whiteboard app to help you understand what's going on. And we are going to cover the necessary background to understand this meeting. So all the timestamps are down below, so you can skip around, do what you want, but let's just get right into it. So this is covering the Endangered Species Act and the Marine Mammal Protection Act. So the Marine Mammal Protection Act was founded by Congress in 1972 and the Endangered Species Act in 1973. So these have a very simple goal, and that is to protect endangered species. Marine Mammal Protection Act was for marine mammals, and then it was, Endangered Species Act covers more than just marine mammals. It covers all the other wildlife in the United States, plant and animal. Now, these acts, of course, were created by Congress. And just as a quick little refresher, Congress are the ones who create the laws and they enact our budgets. So that just means that Congress says we want to create an act that saves endangered species, and here is a budget to do that. Most of the time, Congress works with agencies that they create. So the way this works is Congress, let's show this out. Congress creates an act, or they create a law, they create a bill, whatever. They say we want to do something. We as a country, we are the representatives of the people, so we are going to create some act that enacts the will of the people in some way. Those acts are then given to agencies to enforce. So agencies, and depending on the act, they can go to one agency. They can be segmented into various agencies. For example, the Endangered Species Act is administered by the United States Fish and Wildlife Service and the National Marine Fisheries Service. So two different agencies that have different realms. They operate differently, right? U.S. Fish and Wildlife primarily works with game species as well as non-game species, but its focus is a lot of game species, so things that you hunt, like deer, quail, etc. The National Marine Fisheries Service then works on our fisheries stock around the nation. So ultimately, what we're getting at is that Congress creates our laws, and then they give those laws to agencies. They give directives to those agencies to actually fulfill their wishes. Okay, the issue here, the main issue with this meeting, are how these agencies are supposed to enact that will of Congress, and specifically, who has oversight over these committees and their actions. So, Congress actually has a very fascinating tool to use when they're building out acts, when they're building out new laws, and that is ambiguity. That's right. The vagueness of a law actually sort of translates to the power those agencies have. In general, a more vague laws give more power, so more vague, more power to agencies, and generally, the less vague, the less power an agency has. So let's say Congress creates a hypothetical act that wants to reduce water pollution, okay? So this is a brand new act, and we say we want less H2O pollution. Now, the letter of the law, the language of that law, is going to influence how these agencies carry out this mission, because there are many ways we could decrease water pollution, right? So let's say that Congress gives them a vague directive. So it could just be decrease water pollution. Everyone signs off, that's it. They give it to some agency to carry out. Well, how are they going to decrease it? They have a lot of options. They have so many options that they ultimately, it goes down to their best, their expert knowledge, right? They are going to say, hey, we know what to do about water pollution and we are going to enact it. And let's say they start doing things like fining companies. Okay, they start imposing giant fines for companies to decrease water pollution. Let's say they also mandate testing of all waterways by local governments. So this agency has the power to do so because the letter of the law was very vague. Maybe they also do something that's a little bit extreme. Okay, let's say that they actually, if the water is too polluted and they know that there's a big polluter, they can actually dissolve the company. Okay, now this is hypothetical. So, because the letter of the law is vague, ultimately what happens is those agencies have a lot of power to work on these issues. But that doesn't mean they have all-consuming power, because we still have a legal system and we still have Congress, which can make updates. So maybe that agency decides to try and dissolve a company, which is, a crazy response to water pollution, right? That company takes them to court, and then a judge would look at the totality of information and say that dissolving a company falls way outside what was meant by Congress. And they'll ultimately say that no, this agency was not acting correctly. So now there is a precedent saying that these agencies can't dissolve a company over water pollution. Okay, so that is one way that these agencies are checked. Their power is checked are through legal decisions. And we already know that with the Endangered Species Act. They get sued all the time and they win about 70% of the time. But that also means that 30% of the time they don't. So there is a balance of checks and powers, checks and balances that check power. Okay, but there's another way that these agencies can be curtailed, and that is by updating the law. So let's say Congress realizes that they kind of didn't really give this act any guardrail. They didn't tell this agency how to do things. Okay, so what they do is they then amend this act to say something more specific. So they say that they are tasked with lowering water pollution by imposing fines. And by requiring tests. So this is one way of curtailing an agency's power. Again, they are just saying that, hey, you have this power, but now we're going to make it more specific so that you can't just work within that ambiguity. And often, I mean, this happens often. There's amendments to laws all the time. But where the trickiness gets into, where this gets tricky, is within that vagueness, within that ambiguity. How much leeway do these agencies actually have? So this basic framework where Congress creates laws and then the courts can check agency powers and Congress can amend laws to give the agencies more or less power, depending on that ambiguity. This comes from something called the Skidmore Deference from 1944, where the courts are typically deferring to an agency's interpretation of a statute, so that interpretation of vagueness, but it doesn't mean that the courts automatically agree with the agency's interpretation. They say that the agency still has to prove it, but they are giving the agencies that opportunity to prove it, right? They are saying that you guys have expert knowledge in this hypothetical example of how to reduce H2O pollution. You've hired the best experts to understand it, and I know you're working within the laws that we currently have. So, of course, maybe dissolving a company was within the laws, but maybe it wasn't. And that is where the courts come into play. That is where judges can say, this is not a good interpretation of that law, so we're not going to nix it. But that actually brings out a big issue. And it is that judges have a lot of power to curtail and to influence how agencies operate. And this was a major, major issue because judges with personal policy preferences, again, many judges are appointed by the president. So if the president is saying that, they appoint judges that are against water pollution, they just don't like it, those judges may have a personal policy and may be overly strict to the agencies and ultimately make it very difficult to operate. And again, judges are turned over fairly often. And another major issue is that if a company doesn't like this, the dissolved company gets super mad, or maybe one that just is mandating testing, right? They say that it is too powerful. These companies can shop around, quote unquote, for judges that are favorable to their cases and sue in hopes that they get that judge to ultimately strike down and be part of the company. And of course, this goes in the opposite way. If there's like some hardcore environmental lawyers, they may use this, they may realize they have that power to give those agencies a ton of legal jurisdiction, a lot of leeway. So ultimately what I'm trying to get here is that judges underneath this system have a ton of power. And what changed is the Chevron Doctrine in 1984. So this is going to be a great example of a great real example. So in 1984, the EPA, the Environmental Protection Agency, was interpreting the Clean Air Act. So the EPA allows states to issue permits for groups of polluting devices. What does that mean? So let's say that you own a chemical plant of some type, and because you are in the United States, you have to follow regulations and laws, particularly around the Clean Air Act. You have to make sure that you don't have, too many smokestacks that are polluting into the atmosphere. So the way that the government actually works is by you apply for a permit to build one of these combusting devices. So underneath original laws, underneath original ways of the Environmental Protection Act, how they used to operate, you would have to get a permit for every single one of these combustion devices. So if your plant had 5 of these combustion devices, so maybe whatever those fall underneath on the legal spectrum. So if there's 5 of these, you'd need 5 permits. Okay, even though they're all on the same plant. And that's because, each of them pollutes, so you'd want to get a permit for each. But underneath a law, underneath a new directive, the EPA wanted to essentially make this permitting process just a lot easier. And they created what's called a bubble zone. So essentially, if it was on the same site and they were all of the same type of device, so all of these are combustion devices, you could just apply for a single permit for all of them. And what that also meant was that if you wanted to update these devices or even add new ones on your site, as long as they did not increase the amount of pollution, you did not need to apply for a new permit. And this was seen as a massive push for deregulation. This was underneath the Reagan administration. So they were actually sued. The EPA and a few other companies, like Chevron, for example, they were sued by the Natural Resources Defense Council, an environmental advocacy group, saying that, of course, they would give them too much leeway. And they were specifically referencing that the Environmental Protection Agency gave too much leeway as to the statute from Congress. They said that this was a really bad interpretation of those laws from Congress, and the EPA should not be allowed to do this. This went to the Supreme Court, and the Supreme Court unanimously sided with the Environmental Protection Agency and Chevron. So they actually were against the Natural Resource Defense Council. And this was a unanimous decision. And ultimately, the Supreme Court rejected it, going back to that issue with the judges that we talked about, that judges do have too much power. And in fact, there is a specific quote: "Judges are not experts in the field and are not part of either political branch of the government." Courts must, in some cases, reconcile competing political interests, but not on the basis of the judge's personal policy preferences. And this was what became the Chevron Doctrine, a really, really important piece of legislation, legal history that has actually been one of the most widely cited legal decisions in US history. Because ultimately, the Reagan administration thought that this deference would actually, it was deregulation, but they thought it would make the federal government much more efficient. That government agencies, which Congress creates, would actually have a lot more ability, to a lot more flexibility to enact that will. So the Natural Resources Defense Council, they were worried that this efficiency and those really broad interpretations would strengthen the executive branch, essentially allowing whomever the president put in charge, again, whatever judges the president appointed, would ultimately give them a lot more power. And that can be very good or bad. Because, yes, while this was a deregulation underneath Reagan that helped industries basically skirt this permitting process a little bit easier, it has also been used, that Chevron Doctrine has also been used to enact climate change policy, a whole suite of anti-pollution measures, and, of course, the protections for endangered species. But the Chevron Doctrine has been used for much more than environmental issues. The Chevron Deference has been used for LGBTQ rights, healthcare, civil liberties, and more than 18,000 federal court decisions that have referenced this deference. It has provided over 40 years of legal precedent and is how all of these agencies in the United States actually operate. They have built their entire agencies around this agency interpretation. Specifically, what the Chevron Doctrine did was it didn't get rid of the ambiguity issue from Congress. It actually really focused on that. And now there is a two-parts process for interpreting vague statutes. The first is to actually determine if the statute is ambiguous or not. If the statute is not ambiguous, it's very specific, then the inquiry stops. If the act was supposed to reduce water pollution and it says only through fines and required testing, and then they try to dissolve a company, then obviously that's way outside what the act actually says. So inquiry stops. But if the law is vague, they then have to determine, is it intentionally vague or not? Vagueness sometimes just happens, right? Congress thinks it looks good, and a lot of eyes, a lot of people, lots of amendments, but ultimately it is not intentionally vague. So that may have to be considered. But if it is intentionally vague, whatever, the agencies they determine if that agency's interpretation is reasonable. So is this a reasonable interpretation of those statutes, of that vagueness? If, that says enact the will of Congress, maybe there's a lot of different ways that something could be very wrong. If it was we want to lower water pollution, and they say by imposing fines. Yeah, if they impose a fine, but if they impose a $40 million fine for someone littering, throwing a can outside of their window, that would be unreasonable, right? That is an extreme fine, even though it's within the vagueness, the allowed vagueness of the law. And so this is the Chevron deference. And this is really, really important because what it does is it takes it out of the power of the courts. The court is not to decide, is this the law, right? They're not saying that this is the law. They're saying that the agencies have the power to interpret the laws. They are only determining if those laws are interpreted reasonably, right? So it really does curtail the power of the judges considerably, because even if they have a personal policy difference, they disagree with something within that law, it can be found that it just needs to be shown to be reasonable, and they're deferring to it. So Again, this is a very complicated process, and I am dumbing it down a little bit. This doesn't mean that the agencies are, they can do whatever they want. They don't have total power. Again, they're taken to court all the time, and they lose about 1 in 3 cases, which is pretty impressive. Pretty impressive check of power considering how litigious this country is, especially the giant corporate lawyers that have teams and teams of people who will just file lawsuit after lawsuit after lawsuit. And even then, even with that, agencies lose about 30% of the time. So, the power is checked. Okay. So again, this has changed. That Chevron deference was incredibly important, but that changed in 2024, which was on a case brought by the fishing company Loper Enterprises against the National Marine Fisheries Service. Their dispute was over who pays for the federal monitor. So we have our fishing boats, they go out into the ocean to fish, and we have it in law that they need to have a federal monitor, someone on the boat from the federal government who is checking to make sure that those fish quotas are accurate. So if they're only allowed to take in 300 tuna and then they catch 400, the federal monitor is there to catch that. The issue was who is paying that salary. And it is about a $700 a day salary. And the issue was that at the time of the lawsuit, the cost was paid by the fishing companies. The National Marine Fisheries Service was saying that the cost, that $700 a day cost, is going to be offset by increasing prices. So they put it on the fishing companies to increase prices to offset that cost. My personal opinion, if the federal government mandates something, they should pay their federal workers. I fully believe that. I think this was a very understandably, why? Because government's requiring it. There's a lot of legal stuff, but in my opinion, I think the government should pay for their own federal monitors. Anyways, what happened was the Supreme Court ruled 6-2 in favor of the Loper Enterprises, but they actually completely overturned the Chevron Doctrine. They didn't just say, the courts didn't just decide, the Supreme Court, this was a 6-2 decision. They, instead of saying that the federal government has to pay for the federal monitors, or saying that someone else has to pay for it, or that basically the fishing companies don't have to pay for it, they decided to overrule and nullify the Chevron Doctrine entirely. 40 years of legal precedent, 18,000 cases that have deferred to it, and how all of our government agencies actually operate. They said it's no longer a thing. Now, what they did was they essentially removed that second step of that process. So where they have to determine, is a law written vaguely or not? Then you determine that, is the agency's interpretation reasonable? They removed that reasonable interpretation clause. And what happened is now we're basically back to this original scenario where the judges now have a lot of power to determine if the agencies are interpreting things correctly. And remember, this is an issue that the original Supreme Court decision underneath Reagan with a lot of conservative judges said judges are not experts in the field and are not part of either political branch of the government. Courts must, in some cases, reconcile competing political interests, but not on the basis of the judge's personal policy preferences. Ultimately, this is a major, major issue because now federal judges decide on policy interpretation, not the expert agencies. And this ruling is very recent. This happened just last year, just 6-7 months ago. We've already seen the effects. In 2024, the Air Force refused to comply with EPA order to develop a cleanup plan for clean drinking water they contaminated around Tucson, Arizona. And the Sixth Circuit recently blocked net neutrality regulations by the FCC. So, as a reminder, the Chevron Doctrine was used for a lot outside of environmental advocacy and environmentalism. It was used for a wide variety of government agencies and legal decisions. But that court case, the Loper decision, was not at all clear on what they are going to replace it with, or it's sort of assumed that we are now going back to this 1944 Skidmore deference, where it's in this judge's hands, and that's seemingly how the courts are responding. So this is worrying me considerably. We are in a second Trump administration. In Trump's very first term, he packed the courts at a rate double all previous presidents. So he packed the same amount of, around the same amount of judges as Obama in half the time. So he packed the courts with conservative judges who presumably would carry out his wishes and his personal policy preferences, not those of Congress. And we need to explicitly talk about Project 2025, because at the time of recording, around 36% of Project 2025 has been implemented. This is a tracker. Again, the link is down in the description. And what really worries me is that if you search for endangered species, they specifically talk about delisting the grizzly bear and the gray wolf from the Endangered Species Act, as well as reinstating Trump's limitations on the Endangered Species Act definition of critical habitat. So there are specific policies written out in Project 2025 that talk about the Endangered Species Act and also giving the agencies more power. This is really concerning because these talking points were found all over that meeting. It was a hard focus on grizzly bears. So just to give you a little bit of the conservation background, if you actually, one of the main things they said, it was actually in the opening statement, that grizzly bears have met their recovery goals every year for the last 20 years. Why are we still protecting the grizzly bears? And yes, that's a reasonable question, but it fails the moment you look at the actual conservation plans. Those are minimums. Those are what they want to reach every year. And saying that they are reaching them every year is just saying that they're working. They're doing their job. They are reaching a minimum standard. They are saying, this is our goal, and you're upset that they are reaching their goal. But here's the thing. Since the 1993 recovery plan, I'm quoting specifically from the grizzly bear species survival plan, that we, the U.S. Fish and Wildlife Service and the agencies, have evaluated and update how they assess recovery criteria as newer and better science become available. Those revisions include implementing new scientific methods to determine the status of grizzly bears, estimating population size, determining what levels of mortality the populations could withstand to maintain recovery goals. What I'm trying to say with that is that they are updating their goals every single year. They are updating them with new science. They're saying, hey, we had an old goal based on the new science. Here's our new goal. But also, here's the thing about their goal. Their goal is to maintain a minimum population size of 500 grizzly bears and at least 48 females with cubs of the year. You know, again, I want to cover this more in depth, but not in this video. That is not a good population size. They actually say that this is the estimate for the minimum population threshold that will ensure the short-term fitness of the population, not threatened by losses in genetic diversity. So this isn't even saying these are recovered and these are great. They're saying this is our minimum goal. We are trying to keep them at a bare minimum, pun unintended. So ultimately, what I'm trying to get at, and I'm going to stop the video here because I know it's getting long, this meeting is covering how agencies can actually enact the will of Congress and what powers we have to say, are agencies doing the job right? Are they actually enacting the will of Congress correctly? Ultimately, what I'm worried about is just how much uncertainty we have around all this. We have removed 40 years of legal precedent based off of one court case, which the Supreme Court could have decided in a much less impactful manner. And our conservative packed Supreme Court has been doing this quite often. They have been reversing the set precedents of our land, of how we actually operate on here. And when you pair all this information with the knowledge that the conservatives in this meeting are taking talking points directly from Project 2025 without doing any research at all on these species, it is concerning. It is massively concerning. And so I'm going to try and keep you updated. I want to do more videos that are just like this, and I'm going to try and find time to break down the conservation of grizzly bears, conservation of gray wolves, and everything. But yeah, this was a very long meeting, and unfortunately, it's just hard to cover everything that they said. So you can watch the full meeting there, but I really wanted to make sure that this background was out in there. And there's a few more sources down below. So, hey, thanks for joining. And if you have any questions or want me to cover something new, let me know. I'm going to be doing more. So, yeah, have a great time. See ya.